matter of Karin Baldwin Berabic versus Carl Berabic.
For the record, this matter is before the court on the defendant's motion to modify child support. This hearing is being conducted via Zoom. Present is Attorney Kirsten Nemec, representing the defendant petitioner Carl Berabic. Mr. Berabic is present. In addition, Attorney Maria Zagorski is present, representing the plaintiff Karin Baldwin Berabic. Good morning, Ms. Nemec and Ms. Zagorski.
Good morning, Your Honor.
Good morning, Your Honor.
All right, the parties have conferred with Ms. Barber from the front of the court, who's provided the court with the following recommendation: that the parties shall mediate the issues of parenting time as well as child support with Ms. Stephanie LaPrade on Friday, January 17th, 2025 at 8:30 a.m. via Zoom. In the interim, the children shall attend school every day on time unless a doctor's notice provided. The parties shall not discuss finances or any aspect of this case with minor children. The parties shall not negotiate parenting time through the children. Seems all appropriate. Ms. Nemec, is this recommendation agreeable with your client this morning?
It's not agreeable, but there are some requests that I have. First, the minor children are 15 and 17, and the current parenting time order is reasonable and liberal, which I believe is appropriate for children this age. Ms. Baldwin has indicated that she is requesting specific parenting time, and of course that's her right. Our motion was not to modify parenting time because, again, I believe that reasonable and liberal is appropriate with children this age, and it's been working out. The children have been moving back and forth between the parties' homes since Mr. Barberic's return to the Monroe County area in June, up and until he filed this motion, at which point Ms. Baldwin has started to tell the children that they cannot go to dad's house. She is claiming today it's because the children are late to school when they are in his care, so on and so forth. The children have been late to school in both parties' care. The children have missed school in both parties' care. One of the children has a little bit of a rebellious streak, and he has done things like sneak out of the house or, skip school. He's done that. He's snuck out of Ms. Baldwin's house. So there's a lot of focus now saying that Ms. Baldwin is preventing the children from coming over to Mr. Barberic's home out of concern for them. And of course, because parenting time is reasonable and liberal, she's able to do that. I just want some instruction from the court, if possible, that it's not appropriate. These children should be able to see both parents, and at 15 and 17 should have a say. I would like to see an investigation, and I would like to see the children interviewed, because at 15 and 17, I think that their input is important. These are not 5-year-olds. They are 15 and 17-year-olds. We asked for an investigation. Ms. Baldwin objected. I'm sure we'll hear the objection on the record. But I do think it would be informative. We've got plenty of time to get that done ahead of the mediation scheduled in January.
All right. We'll hear from Ms. Zagorski, but also what about, the party talked about more supporting about the holidays. We have Thanksgiving and Christmas coming up. Do we need to, if we need a specific schedule, let's at least address those holidays if we need
Judge,
to.
the parties use the front of the court holiday schedule. Dad has Thanksgiving, and so he'll see the boys for 4 weeks, or excuse me, 4 days starting tonight.
That's accurate. It's in the judgment of divorce.
Right. So obviously the remainder of the recommendation is agreeable. Ms. Nemec, asking the court to simply order that the parenting time issue be referred to the front of the court with the children be interviewed. Is that correct?
Correct.
Right.
And I would like Ms. Baldwin not to interfere with Mr. Barberic's parenting time. If the children request to go to Mr. Barberic's, I would like that to be allowed, given that we have an order that says the children have to be to school on time. The children have to go to school unless they have a doctor's note. I think that should be sufficient to address any concerns she has or the allegations that she's making that those things occur only when they're in Mr. Barberic's care, which is not factual.
Right. Thank you. Ms. Zagorski.
Yeah, that's the antithesis of what's needed in this case, Judge. My client feels very strongly that the last thing that should happen is that the boys should be put in the middle. That's what's causing the problem now. The communication about parenting time is going through the children and not the parents. The children are driving the bus, and that has to stop. These children are 15 and 17, but they're still minors. And as I said to counsel, teenagers need more supervision than toddlers. The parents need to be communicating. And the problem has been that dad talks to the boys about coming over. And then when mom reasonably says that doesn't work for this reason or this reason, then the boys get angry at her. It's been complete manipulation of these children. And the goal here is to take them out of that. So referring it to the front of the court so that they think that they have an even bigger voice and that they get to decide what's best for them is the antithesis of what should happen. I've attached the text. Dad lets them go to concerts on school nights and he's gone for work before they get up in the morning, so they don't have to go to school when they're at his house. That's been the problem, and that's what the evidence would show. So I would respectfully request that the parenting time be coordinated through the adults and not through the children. There's no need to spend time and money on a front of the court investigation when the children should have less say about what's occurring here. It's time for the parents to step up and do their job.
Well, but then for that reason, perhaps we need a specific parenting time schedule. What has been the practice of the parties the last 2 or 3 months?
The children have been spending, per my client, fairly equal time with him. As I stated before, at the time of the entry of the judgment of divorce, Mr. Berabic did not live in the Monroe County area, and he also worked midnights. And so he wasn't able to exercise overnights with the children. Obviously, they were younger at that time as well. He since moved into the county in June. And since that time, increasingly, the boys have been spending more and more time with him. They haven't worked out any type of specific schedule because they were kind of just allowed to say, hey, I want to go over to dad's. Hey, I want to go over to mom's. And that was working out until Mr. Berabic filed this motion.
Judge, we're mediating the issue of a specific schedule in January. My client has facilitated his parenting time and will continue to do so. The problem is, like I said, when the boys don't go to school or when dad lets them do whatever they want on school nights, that's the issue, which is why we suggested every other weekend until we get to mediation. And then we can figure out something more than that when we can encompass the summer and other times.
I would disagree that mom has been facilitating dad's parenting time. She has been actively preventing his parenting time since the filing of this motion. I wouldn't disagree to ordering a specific parenting time schedule to get us through to the mediation, but Mr. Berabic has been exercising fairly equal parenting time. We admit that he didn't prior because he worked midnights and he did not live in the county, but he has been, Ms. Sikorsky, he has been for the last few months. And again, while I understand she's requested a specific parenting time schedule, she's entitled to a specific parenting time schedule, I don't know that it's necessary, but I know that I cannot prevent it. I really think the children have been thriving under the current situation. I don't think that Mr. Berabic has communicated with them inappropriately about spending time at his house. Again, this is a 15-year-old and a 17-year-old, and quite honestly, the communication between the parties is abysmal. It's absolutely terrible. So he cannot rely on Ms. Baldwin to facilitate his parenting time or communicate with the children for him. He has a direct line to the children himself. He's not attempting to manipulate the children. He's spending time with his children. They are equally his as much as they are Ms. Baldwin's.
I don't know how you argue that my client doesn't facilitate parenting time and that they've been exercising 50-50, Ms. Nemec. That doesn't make any sense to me.
I'll clear it up for you.
Excuse me. The truth is he bought a house in town, which is great. My client said, wonderful, boys, start spending time at your dad's. And they did, and it didn't work, which is why she's asking for a specific schedule. It didn't work because they were missing school, because they were late for school, because they didn't have the guidance that teenagers need. And so we need to put some rules in place. At the same time, dad was communicating through the kids and they know how to work it. They're teenagers. That's what has to stop.
They were missing school and skipping school while they were in Miss Baldwin.
That is absolutely not true.
Well, the evidence.
Okay, so I think we need to establish a specific schedule this morning. What has been the past practice since July, Ms. Nemec?
Mr. Berabic, can you isolate days of the week that
I'm going to put you back and break over this bar. The court wants a specific schedule now between the time you mediate. That's how we're going to take the children out of this. The court's not going to order they be interviewed. If we cannot resolve in mediation, then the court can at that time ask that the children be interviewed. But I want to set a specific schedule between now and that mediation date. If that takes the children out of it, and I think both parties are better served by having a specific schedule today. So Ms. Brown, if you can talk further about a specific schedule, please.
Yes, Your Honor.
If they're not recommend, I'd like to see what the parties been practicing. Try to be consistent. What's best for each other's work schedules.
Okay, thank you, Your Honor.
All right.
Calling the matter of Brittany Beers versus Jeremy Raditz.
For the record, this matter is before the court on the defendant, Jeremy Raditz's motion to revoke paternity. This hearing is being conducted via Zoom. It appears that both parties are present. Brittany Beers as well as Jeremy Raditz. The parties have conferred with Ms. with Ms. Patrick for the front of the court this morning. Ms. Patrick has provided the court the following recommendation that the defendant's motion to revoke parentage be granted as defendant is not the biological father of the minor child based upon DNA testing, that this case be dismissed. And Mr. Raditz, this is what you're requesting, correct?
Yes, sir.
Okay, Ms. Beers, do you agreeable with this recommendation?
Yes.
For the record, the court recognizes this child is 12 years old. Normally, the courts would not allow such relief, but the court is of the recollection that this minor child, Aubrey, does not look to father Mr. Raditz as a father figure. Is that correct, Ms. Beers?
Correct.
And Mr. Raditz, you have really no relationship with this child. Is that correct?
That is correct, Your Honor.
Of course, you allegedly signed an acknowledgement of paternity when the child was born. That's why you are named as the defendant in this support action. But the court is in receipt of a DNA test report. That's contained in the court file dated October 4th, 2024, referencing the minor child and both parents, and indicates a 0% probability of paternity. And Ms. Severes, the court recalls you previously alleged that one Brandon Thornton is the biological father of this child. Is that correct?
Yes, sir.
Okay. Does Mr. Thornton have any relationship with Aubrey?
He's in and out.
Okay.
Yeah, that's all I have to say about that. More
Okay.
out than in.
All right. Well, and you're aware that, of course, if this relief is granted, that this case will be closed, and you'll need to, when assistance is cut off with my child, you need to come back in front of the court and name the bio dad, and they need to start an action against Brandon Thornton. You understand that?
Yes.
Right. Very well. The court will grant the relief requested. The court determines that defendant Jeremy Raditz is not the biological father of the minor child Aubrey. His motion to revoke parentage is granted. This case is dismissed. You both be sent a copy of this order. The child has the last name of Raditz, but if you want that changed, I guess you perhaps have to talk to an attorney.
Okay.
Change that name. All right. Any questions?
No, sir.
All right. That'll conclude this matter. You can both zoom out.
Thank you, Your Honor.
Thank you, Ms. Patrick. Court will call the case of India Sundermeyer versus Noah Harris.
Yes,
This matter is before the court on the plaintiff's motion to modify custody, parenting time, and child support. The hearing is being conducted via Zoom. President Attorney Bert Whitehead. Mr. Whitehead is present, and Ms. Sundermeyer is present. And Noah Harris, you're present on audio. Is that correct?
I'm sorry, I can't understand what you're saying, sir.
Are you Noah Harris?
Yes, I am.
Okay, Mr. Whitehead, we've been doing Zoom for all proceedings for the last 5 years. You did not provide Zoom instructions. Both parties appeared personally today, and they're both upset that they were told they had to go appear on Zoom. I think you've been to this court before. You're appearing by Zoom. Why would you not instruct the parties with Zoom instructions with your
Honor,
notice of hearing?
because when we had, Your Honor, I apologize for that, but when we emailed the court and asked for a court date, we were given the court date, and then I wrote an email specifically that said, could I appear via Zoom? We were not giving Zoom instructions at the time, so then I
I asked
emailed.
for them. We've been doing things, every case other than the trial, all motion hearings are by Zoom, 100% of them, Mr. Whitehead. It's been since 2018. So I always ask to make inquiry. I understand some courts may be in person, but not this
Yeah.
court. So in any event,
yeah,
both parties were not pleased when they appeared this morning and had were to send back home. In any event, we're
I
backed up this morning. The front of the court is short. So I'm going to have you talk with Mr. Harris, Mr. Whitehead, see if you can come to an agreement. If so, we can bring you back out, but we're short in terms of front of the court talking with the parties.
I understand.
Basically, you're alleging that dad is not exercising parenting time the last 2 months. Is that correct, Mr. Harris, that you've not been exercising parenting time?
I'm sorry, Judge. I can't understand a word you're saying. The audio coming from you is all muffled and it sounds very robotic. I really am having a hard time hearing the words you're saying and making out what you're saying to me.
Okay, can you get on a different device? Are you in here in the
Okay,
courthouse, Mr. Harris?
I was in the courthouse. I had to come home because my phone was dying and my microphone is malfunctioning. So I came home to get a different microphone to hook up to my phone to call in. I am at home now. I'm going to try to hook up to the computer and see if I can get on that way.
That might be better. Mr. Harris, Miss
Yes, sir.
Sundermeyer is alleging that you've not been exercising your parenting time the last 2 months, so they want to modify parenting time to be consistent with what you've been doing. Is that true?
Yes, sir. I have not seen Clayton since August
Okay, and why is that?
because I was recommended by the police for the well-being of my other children to not bring him around the home. So I've made attempts to contact him and I tried to see him on his birthday and I was denied. I've been denied phone calls. That
I
is
don't know
why
what you're
I
talking
haven't
about.
seen him.
Yeah, you're saying the police told you not to exercise parenting time?
I'm sorry?
You say indicate the police told you not to exercise parenting time?
They told me to think about the well-being of my other children and that it's not safe for Clayton to be in this home because of the way he's treating the other children. He's touching them in a sexual way.
And
He's sexually assaulting my other children. And so I can't have him in the house around the other children, but that doesn't mean I can't see him or talk to him. So I've tried to make phone calls and I'm trying to do what I can to be there and help him, but I don't think he's safe.
If I may say, I have not.
Mr. Hold on, Ms. Sundermeyer, just please.
Yes.
Mr. Harris, you have parenting time alternating weekends. I'm sorry, every weekend, Friday to Monday. So I'm not sure why you're not exercising that parenting time. All right, I'm not sure if the three of you can reach an agreement. Mr. Harris, you're going to change your device to get on your computer. Is that correct? And zoom in?
Just 1 second, please. I'm sorry.
Okay, we're going to put you back in the
I'm
breakout
having-
room. Why don't you get on your computer, zoom back in, and we'll wait for someone from the front of the court to speak with the three of you.
Thank you, Your Honor. I appreciate it. And sorry about the mix-up. I thought I was only approved for me to join Zoom and that the parties would still have to be in person, but I apologize for that.
Okay, we'll put you in a breakout room.
Thank you.
For the record, this matter is before the court on the plaintiff's motion to modify custody and parenting time. This hearing is being conducted via Zoom. President is Attorney Anthony Bresco, representing the plaintiff moving party, Kevin Brooks. Mr. Brooks appears to be present with Mr. Bresco. In addition, Mother Alyssa Collinsworth is also present. Good morning, everyone.
Good morning, Your Honor.
The parties have conferred this morning with Ms. Brower from the front of the court has provided the court the following recommendation. That the parties continue to share joint legal custody, but physical custody shall be awarded to the plaintiff father on a temporary basis without prejudice. Parenting time on a temporary basis without prejudice shall be every Tuesday and Thursday after school to 8:30 p.m. and every Saturday 10 a.m. to Sunday at 10 a.m. Mother shall have additional parenting time as the parties can agree. The party shall appear back for its court to review parenting time on February 4th, 2025 at 9 a.m. via Zoom. Mr. Bresco, is this recommendation agreeable with your client?
It is, Your Honor.
Okay, Ms. Collinsworth, do you understand this recommendation this morning?
Yes, Your Honor.
Do you have any objection to, or agreeable with the court adopting this recommendation as an order of the court?
Yes, Your Honor.
Okay, what is your objection?
Oh, I meant I agree. I'm sorry.
Oh, you agree, okay. Mr. Breskel, is this not the same parenting time schedule set forth in the August 2020 judgment divorce?
No, Your Honor, it is a different parenting time schedule that has been mostly adopted since the judgment of divorce. In the judgment of divorce, the parenting time schedule was that dad was awarded parenting time with the minor children that consisted of 3 overnights a week on the days he was not working in the night shift. But this is what they've been doing for the most part. It has changed from time to time, but the majority of the time, this is the parenting time schedule that's been taking place since that entry, Your Honor.
Thank you. Was there any discussion this morning about who can claim children as dependents for tax purposes for 2024, or was that addressed in the judgment?
I don't.
If we each get one.
They're rotating the children, Your Honor, and there's no issue with that. The purpose of today's motion was simply to codify an agreement that they've been exercising for a very long time and reduce it to writing. And we've decided not just to immediately make the change, but to modify it, observe some behavior, and make sure everything's going well for all the parties involved. And that's why we're going to come back in February and take a look at this again.
All right, very well. Ms. Collingsworth, do you have any questions?
No, Your Honor.
Okay. All right, the court will adopt the recommendation, and we'll see everyone back here on February 4th at 9 a.m. Thank you, Mr. Breskel.
Thank you.
For the record, this matter is before the court on a number of issues. Defendant's motion for her to show cause, plaintiff's motion for her to show cause, modified custody, child support, school district. This hearing is being conducted via Zoom. Both parties are present, as well as attorney Leah Worka. Ms. Worka represents the defendant, Father Barry Ellison. Ms. Hills, the plaintiff's attorney, Ms. Williams' attorney, is stuck in Judge Arnold's court on another matter, so she's not immediately available. But Ms. Worka, you have filed or you will be filing a motion to withdraw, or have you done that?
Your Honor, it was filed yesterday.
Okay, it's not yet in the court file. Did you serve a copy of that motion upon Mr. Ellison?
I did, Your Honor, via email, as well as Ms. Hills via email. I apologize, Your Honor. We did file it yesterday afternoon. I thought my staff had brought a judge's copy up for you at least yesterday. If that didn't occur, I apologize.
I was told that there may be one filed. Mr. Ellison, have you received a copy of the motion filed by Ms. Worka asking that she be permitted to withdraw as your attorney of record this morning?
I think she did, but I haven't looked at it.
Okay. Do you have any objection to her withdrawing as your attorney?
Yes, I do. She, if she doesn't want to be my attorney, she has to terminate on her own because I'm not terminating.
Well, that's what she's done. She is asking this court to allow her to withdraw.
Right.
She's asking, she no longer feels she can represent you, and she's asked to withdraw.
Right. I just went on record that she's withdrawing. I didn't fire her.
Okay. Ms. Worka, do you want to talk with Mr. Ellison in the breakout room, the two of you?
No, Your Honor, I don't believe the breakdown of this attorney-client relationship can be cured at this point.
Okay. So you believe that the relationship between you and Mr. Ellison is such that you cannot, in good faith, continue to adequately represent him? Is that correct?
That is correct, Your Honor.
All right. Do you understand that, Mr. Ellison?
I don't feel she did in good faith any representation, Your Honor.
Okay. So again, you have no objection to her withdrawing. You're just saying for the record, you're not firing her, but you have no objection to her leaving and no longer acting as your attorney. Is that correct?
Yeah, correct, Your Honor.
All right. All right. The court will grant the motion. Ms. Worka, you will submit an order to the court permitting you to withdraw as the attorney of record for Mr. Ellison. And we'll have Mr. Ellison represent himself then this morning on these matters as soon as we can get Ms. Hills back here.
With that being said, Your Honor, is it possible to have a schedule a new day, because I got nothing. I have no attorney at this point.
Your Honor, I did submit proposed orders with the motion to withdraw. I will check to see to ensure that those are with the motion wherever that wound up with the clerk's office yesterday.
Okay. Well, Mr. Williams, why don't you, let's wait for Ms. Hills to come in. The three of you can at least talk. And yes, if you need more time to contact an attorney, we can discuss that. And we can, the court would allow that. Other than these matters been kicked down the street quite a bit.
Yeah, I didn't plan on this. As I say, I found out like in the last 30 hours at the most. So.
Okay. All right. So we're putting you back and break our room, the two of you. And when Cells gets there, you can just tell Ms. Cells you want to retain another attorney. And maybe there's some issues that the small issues that we can maybe agree upon today. So hang on, then Mr. Allison and Mr. Williams will wait for Ms. Hills to reappear. But Ms. Worka, you can zoom out.
Thank you, Your Honor.
Welcome.
On the matter of Kayla Ferozi Kluber versus Carlos Morrison.
For the record, this matters before the court on the defendant, Carlos Morrison's objection to a referee recommend order that bench warrant issue for his arrest. This hearing is being conducted via Zoom. Sir, you are Carlos Morrison, is that correct?
Yes, sir.
Okay. You have appeared this morning, Mr. Morrison, but nevertheless, it appears that you have significant outstanding arrearages, about over $13,000. Are you currently employed?
I just gained employment. I was looking for the previous months, but it's been hard for me to find employment because I don't really have transportation. My license is suspended, so I'm not able to drive myself. So I'm kind of dependent on a friend. He got me the job, and we're going to carpool together. And yeah, I can begin to make payments ASAP. I also told the worker that I would be able to pay like $40, $50 today, but I just really didn't have the means to pay consistently the $497. And it's just last time I did make the payment, when I seen my daughter, she had on some too small shoes. So I took the money that I would pay and bought her shoes and like a few outfits. So I do
That's
for my daughter.
wonderful, Mr. Morrison.
When I'm with her,
They'll
when
give
I
you
see
credit
her,
against your arrearages.
It's not, it don't even out because y'all want the child support payment, but it's like, I don't know. I was in a rock and a hard place. Like, do I make the payment, and then next time I see my daughter, she got on too small shoes, too small pants, and it's cold outside, you know? So.
Okay. All right, you've already told me that, Mr. Morrison. We need payments for his arrearages. When did you receive your last paycheck?
I didn't get a paycheck yet. I start tonight at 10 p.m.
Well, it's not good enough, Mr. Morrison. You've been unemployed figure out what you need to do to straighten out your license.
I tried to call Rebecca Hicks because I went to the Secretary of State, and they told me that Monroe had a suspension on it. And
okay, so here's what you do, Mr. Morrison. Ms. Hicks probably tells you she'll release that suspension if you pay a certain sum. So what you do is you reach out to family and friends, get some money together, come in, and that'll straighten out your license. You need to be focused on this obligation.
Yes, Your Honor. I did reach out to her, and I didn't receive a call back. I reached out, and my mother reached out. And she said that it's not her that suspended my license. I have tried to resolve that matter, Your Honor.
Right.
But I get the runaround, so I'm confused, and I haven't tried to move forward with it.
Well, Mr. Morrison, you still live in Dearborn Heights?
You said, can you repeat that?
Do you still live in Dearborn Heights?
Yes, sir.
Okay, move down to Monroe. We got a lot of employers that are screaming for employees. I get your job today down in Monroe. I can't believe that Dearborn Heights is that much different. You're just not motivated to get a job. You're waiting for the dream job, Mr. Morrison. You can't do that. There are a lot of jobs out there, especially with the holidays coming up. I mean, restaurants look for dishwashers. Don't be so picky about what you do, Mr. Morrison.
I'm not, Your Honor. It's just the transportation, honestly. That's the only reason. I don't have transportation.
You got a bicycle?
No, I don't have a bicycle, Your Honor.
Buy one. I mean, I'm sure you can borrow a bicycle. People, if there's a will, there's a way, Mr. Morrison.
I got you. I understand.
Mr. Brower, there's a jail time hanging over Mr. Morrison's head. Is that correct? Was he previously found in contempt?
Yes, Your Honor. He was found in contempt on August 29th of 2023. A first finding, he has 43 days hanging over his head.
All right. So, Mr. Morrison, here's the deal. Again, with this new job, do you get paid every week?
Yes, sir.
So when do you get paid next?
Probably I start this
you
week.
You know, when you say probably, you've not started the job yet, correct? You say you start tonight?
Yeah, I start tonight.
Okay, and with whom? Who's the employer?
Champion Foods in New Boston, Michigan.
What are you doing for Champion Foods?
We make frozen pizzas that go to the grocery store, and we make pizza crust for Little Caesars.
I can be working 40 hours a week?
Probably more than that because they said overtime is mandatory.
So what are you working nights, midnights or
Yeah,
what?
nights.
Afternoons?
Nights.
How much should we be paid per hour?
Around, I believe, 16, 15.
Who is supporting you right now?
Myself and my girlfriend. Like I get.
Okay, well,
food-
someone's
food
hold on,
stamps.
someone's putting a roof over your head, someone's feeding you. You look well nourished, Mr. Morrison. So your
That's the
girlfriend
food
supporting
stamps.
you? Are you
My
able-
girlfriend
are you
does pay the
disabled?
bills, but I will get the food for the house.
Ms. Brown, what's the outstanding balance of arrears approximately? Is it still about 13,500?
His current balance as of today is $15,222.79. Of that amount, $14,725.79 is arrears.
When's the last payment that your office received from Mr. Morrison?
He made a $500 payment in the month of June, 2024.
Right, Mr. Morrison, the Attorney General, you're gonna be on the radar. Attorney General is gonna charge you with a felony non-support for which you go to prison. You're on the radar, so I'm gonna do you a favor. I'm gonna have you come down here with a lump sum to avoid jail. And if you do that, it's gonna get your arrears down, so you avoid the Attorney General charging with felony non-support. So when do you get paid? What day of the week? Friday?
I believe Friday or Thursday. Yeah, I can get that information to you a little later because my my HR worker or whatever you call them said they were going to call me at 7 with more job details.
All right. All right, Mr. Morrison, you got 43 days hanging over your head. The court's going to order you personally appear to serve some time in jail a week from Friday, December 6th. I'm going to give you some time, Mr. Morrison, to reach out to your girlfriend, family, and friends to get some money together. Come down with a lump sum cash or be prepared to serve some time in jail. That's December 6th at 11:15. And we'll get you out of jail before lunchtime. You need to appear personally. Monroe County Courthouse, 4th floor, Judge Bronk, Friday, December 6th, 11:15. And what's the current monthly support, Ms. Brower? Is it all arrears?
It's $497 per month.
All right, Mr. Morrison, you're sitting on your hands. If you've been unemployed for 6 months, you should file a motion to reduce your support. Right now, it's clicking along at $497 a month. You can do yourself a favor by filing a motion to reduce your support, saying, I don't have a license, I can't find a job, I'm unemployment, I don't have any income, I'm on food stamps, I want to reduce my child support. Right now, you should come down to the courthouse today to do that. The sooner you file it, the sooner it goes retroactive. If you wait a week to do that, you're going to pay another month of child support. So the court's going to order you personally appear December 6th and be prepared to pay $1,500 cash toward your arrears or be prepared to bring a toothbrush. Understood?
Got you. Yes, Your Honor.
So I'm giving you a week. I'm giving you a week and a half, Ms. Morrison, get together $1,500. $1,500 you need to bring down cash on December 6th. If so, the court will simply give another hearing date. You can avoid any further jail. If you don't have the $1,500, you're going to go to jail. I don't know how many days. It depends how much you can pay that day.
Okay.
The court wants you to keep your job and get on. And if you come down next week, you got $1,500, come down, we can take care of it sooner. You just got to talk with Ms. Hicks and the court. We can do this sooner than next Friday. If you come down, say on Monday, you got $1,500, we can adjourn the matter, and you can pick up a packet to reduce your support. You can do it all at one time. File a motion to reduce your child support. Be smart, Mr. Morrison. You're sitting on your hands. You're just digging the hole deeper by doing nothing. Do you have any questions, Mr. Morrison?
Yes, I've been meaning to ask. Do that for the motions for me to file, can I do it online or I have to get it from the courthouse?
Ms. Brown, do you know, can you file such a motion online?
The packets are available on our website. It does need to be submitted to the courthouse in writing. You can't submit that online. So you
Okay,
can
get
mail
the
it in,
forms on.
or you can bring it to the
Okay.
courthouse.
You get the forms online, Mr. Morrison, but you come down here and get a copy of the forms. The front of the court will even assist you. They give you a packet, a support packet you can fill out, and you got to follow the clerk's office. So you got to come down here to really complete the whole process. So the court's suggesting, and we'll get them ordered to appear Friday, December 6th at 11:15. It's a week from Friday. And if you want to avoid jail, then you need to bring $1,500 cash to apply toward your arrears and file a motion to reduce your support. The court suggests if you can do that, get the money together, come down on Monday or Tuesday. We take care of it before Friday.
Okay, Your Honor.
Do you have any questions?
No, Your Honor.
Anything with respect to the recommended order, Mrs. Brower? What do we do with that? I guess the court should adopt the roughly recommended order. Even though Mr. Morrison's appeared today, we can cancel it on Friday if he appears, correct?
Typically, we would set aside the authorization and treat it as a show cause contempt hearing next Friday.
Okay. That's fine. So do you need
I'll
to prepare
prepare
a
the order
recommended
for
order?
you. Yes.
Okay, all right, thank you. All right, Mr.
You're welcome.
Morrison, you're all set. Have a good Thanksgiving, and do reach out to family and friends, get that $1,500 together.
Will do.
All right, see you next week.
All right.
For the record, Mr. Slaughterbeck is appearing via Zoom from the Monroe County Jail. Also present is Monroe County Friendly Court Attorney Rebecca Hicks. Ms. Hicks, can you provide the court some information about Mr. Slaughterbeck, please?
Certainly. This case has a current support obligation of $658 per month. The current balance is $14,411.22. Mr. Slaughterbeck did make a payment of $200 on September 20th of this year. Prior to that, we had not received a payment since May. And there is no prior finding of contempt yet on this file.
You're asking the court to commence contempt proceedings, is that correct?
That's correct, Your Honor.
All right, Mr. Slaughterbeck, let me ask you first, are you currently employed?
Yes,
With whom?
Guardian Glass in Carlton, Michigan.
Good paying job, is it not?
It's supposed to be automatic, my child support.
Well, it's not. If you look at your paycheck, it's not coming out of your paycheck, you need paid directly.
I thought it was supposed to be automatic because the last 3 years I've only paid $200 cash because everything else was always coming out of my checks.
That's correct. If there's income withholding on a place, that would come out of your check, but you need to look at your check to see whether it's coming out. Most people look at their pay stub and say, I'm really short this week. Why is this money taken out of my check? And it should show that it's going to the front of the court. You should know that. It's not been coming out. There's not been a payment since September. How long have you been employed by Guardian Glass?
How long have I been?
Correct.
95 days now.
Are you gonna have a job when you get out of jail?
Yeah.
Okay, we're gonna have to post some type of cash bond, Mr. Slaughterbeck. This way, reach out to family and friends. You understand you're being charged this morning with civil contempt of court for failure to pay child support. Upon conviction, you could be ordered to serve up to 45 days in jail. Since there's a distinct possibility of jail, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. Do you understand all of that?
Yeah.
Are you asking for court-appointed attorney?
I don't want to be in here because I swear it was supposed to be automatic. I even spoke to my HR.
Well, the court will appoint an attorney to represent you, Mr. Slaughterbeck.
I don't know what that means.
Why don't you give me a cell phone number so the attorney can reach you by your cell phone if you're able to post bond.
Oh, my phone number?
Your cell number that attorney can reach you at.
7.
How long have you been employed by Guardian Glass?
About 95 days, 3 months.
You paid every week or every 2 weeks?
Every 2 weeks.
Approximate take home. Average.
Average. I've been making about like 750 to like 1200, depending on what days I work. Because 1 week I work a 3-day weekend, and then I have a 3-day weekend off the following week.
You have any other income?
No,
Do you own any property of any value, automobile, boats?
I have my own house, my trailer.
What about automobile?
No, my car it broke down, and I've just been using my parents' vehicle at the moment. They've been letting me use it.
Okay. When did you last get paid?
Last get paid. So I had a seizure last week, my very first seizure ever. So I haven't been working since then.
Thank you.
What?
When did you last get paid, Mr. Slaughterback? That was a question.
I believe the 16th or 17th.
Last week.
Because my next pay period is the 29th.
Okay, how much do you have left of your last paycheck?
I didn't get paid. I didn't go to work because I had a seizure. I have a stress test the 29th.
The last paycheck, how much, when you said you received a paycheck last week on the 18th or 19th?
I would have to look at my phone. I don't.
Okay.
I don't
Do you
know.
have any bank accounts, Mr. Slaughterback?
All my information would be on my phone.
Do you have any bank accounts, Mr. Slaughterback?
Yeah, I have a credit union account and a Dayforce.
Okay, how much is in those accounts approximately?
Dayforce has $2 and credit union has 134.
Okay, do you have any cash at home?
No.
All right. Okay, the court will grant your request, court appointed attorney, Mr. Slaughterback. So are you on indefinite medical leave?
No, I just have a stress test the 29th and then I'm going back. I have to go through like hypothermia testing and everything to see what caused my seizure.
Okay, when are you scheduled to go back to work?
After the 29th, so 30th, Saturday.
Okay. All right, the courthouse is going to be closed the 29th, so we're going to have you come back on Monday, December 2nd. Afternoons, midnights?
I work 6 to 6, a.m. to p.m.
Okay, do you have any days off? I'm going to schedule a court date for you the first week of December. And if you normally 11:15, is there a day of the week that's better?
I don't know off the top of my head, but my schedule goes, I work Monday, Tuesday, then I'm off Wednesday, Thursday, and then I'll work Friday, Saturday, Sunday, and then my schedule is backwards.
Okay, so a week from today, you'll be off. That's the Wednesday, December 4th.
So I'm off. I would have worked Monday, Tuesday. So yeah, I work Wednesday, Thursday next week.
Okay, do you work Monday, Tuesday, and Friday?
So nope.
All right, well, have you, then you're to appear then personally on Monday, December 2nd, 2024, 11:15 a.m. Well, in the meantime, if you can post bond, what do you recommend in terms of bond, Ms. Hicks?
I'd say at least $1,000, Your Honor, based on the current support and the total arrears.
All right, to Mr. Slaughterback, the court's going to require you to post $1,000 cash bond. So reach out to your parents, any other family or friends, if they can post $1,000, it's going to apply toward your arrearages, not going to fines or court costs. It's going to apply toward your arrearages. It's going to reduce your arrearages. And if you are unable to post that, then we will see you on Monday because we're going to be, the courthouse will be closed the rest of the week. Hopefully you can do that and get back to work on Friday and Saturday. Do you have any questions?
I do. I'm new to all this. I've never actually had to go like this far. So do I have to pay the $1,000 in order to get out of here?
That's correct. $1,000 cash. So you reach out to family and friends, see if they can post that so you can go home for Thanksgiving. Otherwise, you can have a pretty good Thanksgiving over there in the jail. You've been neglected this obligation. You have arrears of $14,000. You've been ignoring it, Mr. Slaughterback.
the last 3 months, I had a daughter and I've been dealing with seizures. Like that's why I've missed my mail.
Okay, but you've been sitting
Like
on
my
your
daughter-
hands. What you could do if you had extenuating circumstances, come into the front of the court, talk to the case, we file a motion to reduce your support. Right now, it's clicking along, add $658 every month. You're digging the hole deeper. So do you understand what's going on?
Yes, but not really.
Okay, what questions do you have?
All my child support was supposed to be automatic. When I went up there and paid the 200, I told them that I was working at Guardian and they said it was on file, that they had it and that everything was sent. My HR even said that they received stuff for the withholding.
Okay, Mr. Slobak, I've already explained to you, talk to the HR department. Maybe they're not obviously doing that. So they maybe there's a breakdown in communication, but you need to look at your pay stub every week. If it's not coming out, you need to pay it directly. That's your responsibility.
Okay.
The last pay the friendly court received was only $200, and that was on September 20th. They received nothing for the last 2 months.
I thought it was going to be automatic after I paid the 200. I remember going to the meeting and her saying I needed to pay more than 50. So I paid 200.
Look at your pay stub, sir. That's all I can suggest to you. And if it's not being taken out, then obviously there's a snafu somewhere. But this didn't happen overnight. You got 14,000 arrears. This didn't happen, and it did not happen in the last 3 months. In any event, your court hearing is December 2nd, 11:15. If you're in jail, it'll be via Zoom. Your attorney will reach you, contact you in the jail, or contact you by cell phone if you're able to post bond. Ms. Six, if Mr. Slaughterbeck posts this $1,000, do you have any objection to him appearing via Zoom?
No, Your Honor, I would not.
All right, so Mr. Slaughterbeck, if hopefully you can post this bond, get home for Thanksgiving, get back to work primarily, then you can appear via Zoom. That hearing on Monday at 11:15. You can step out if you can do it from home. You can come in down here if you wish. Your attorney will appear via Zoom.
I'll go to Zoom. I'm going home.
Make some calls to family and friends, see if they can post that $1,000. And that's going to apply towards your urge. It's going to benefit you. Then when you get out, come to the front of the court and file a motion to reduce your support if you're not making this kind of money.
Okay.
Okay, anything further this morning, Ms. Hicks?
Nothing on this matter. Thank you, Your Honor.
All right, Mr. Slaughterbeck, you can step out. A copy of the order will be sent over to the jail. You get a copy of that in terms of the Zoom ID number and so forth for December 2nd, 11:15. Do make some phone calls this morning so people get some money together, $1,000.
Okay.
Okay, you can step out, sir.